Well, good afternoon. Appreciate you all having me here. I will say this violates a basic rule I have, which is never to argue with a man who is a law enforcement official, has a badge and a gun. So, as a lawyer, I learned that a long time ago. I've been in this community since 1978. Came here and went to work in state government, worked in the House with criminal justice issues, worked with the sheriffs and the state attorneys on all kinds of anti-drug issues in the early 80s, and then worked for Bob Graham in the governor's office doing legislative work. And in 1982, we put two amendments, proposed two amendments to the Constitution, both of which dealt with drug enforcement. One made it harder for criminals to avoid prosecution, claiming unlawful search and seizure. That went into the Constitution, as did another one that restricted the immunity laws so that you wouldn't have to give a criminal the complete bath on immunity. Work closely not only with the sheriffs and the state attorneys on all that, but the Supreme Court and others. So I'm fairly cognizant of the very, very important job that the sheriff does and all of our law enforcement people do. And but I would ask you to sort of separate the question here, because I think the best evidence of why people should be in favor of Amendment 2 is to actually look at the language of the amendment itself that's being proposed. I've spent most of my career either trying to persuade legislators, as I know Wilson Wright and others in the room have done, of what the right thing to do is, and a lot of that time I've had to be the scrivener, the lawyer who drafted something. And I have to tell you, the ballot language is one thing. It's just one little paragraph. But if you actually read what's proposed, the language that's proposed to be put in the Constitution, it's very detailed, and it covers most of the eventualities. And then as a fail-safe, it allows the legislature to come back and further restrict what's to be done here. First of all, a lot of the points that have been raised against this, like Barbara's words, those are all fine, but that has nothing to do with this, okay? Because you have to have a debilitating medical condition. You have to see a licensed Florida doctor. He must examine you, all right? And he must certify that you have a debilitating medical condition. What's a debilitating medical condition? Okay, well, there are several enumerated right here in the language, of the amendment, such as cancer, glaucoma, HIV, AIDS, hepatitis C, ALS, which is Lou Gehrig's disease, Crohn's disease, Parkinson's, multiple sclerosis. And then where the sheriff and everybody that doesn't like this goes crazy is it says other conditions for which a physician believes that the medical use of marijuana would likely outweigh the potential health risks of the patient. Well, the problem is then if you read the rest of the amendment, that refers back to these debilitating medical conditions. I'm going to run out of time in a minute, but I'm going to talk a little bit more about what some physicians that I represent think would constitute these other medical conditions. And they're serious things, like spinal stenosis, where your discs deteriorate and your, your spinal column starts to collapse on itself. Now that's not on the list, but that's a debilitating medical condition. And maybe you don't want to take an opiate that knocks you out all the time. Maybe you want to have something to chew on that would ease your pain. So I'd ask you to keep an open mind and remember, this is not about kids on the street getting drugs. This is about doctors prescribing medicine.
4 minutes.
Good afternoon. First, I'd like to thank Kiwanis and NEBA for this opportunity to talk about Amendment 2, because I believe as the public gets more and more educated about what is actually the language in the amendment, the support for this amendment begins to fall off. I would have to disagree with what was just said about the language being clear as far as debilitating medical condition. Because when you read or any other condition for which a physician believes that the medical use of marijuana would likely outweigh the potential health risk, that's very clear language. It's any other medical condition. And throughout the amendment, it speaks of debilitating medical conditions, but it will always, the law will always go back to the definition. Will always go back to the definition, and that is the definition. Any other medical condition. There are also multiple other loopholes in this. For example, Amendment 2 does not require a doctor's prescription to obtain medical pot, just a recommendation from the doctor. The authors of Amendment 2 define debilitating medical condition as any condition, as we just mentioned, could be back pain, trouble sleeping, a whole host of other issues. In addition to that, there's what we call refer to the drug dealer loophole. That's where these so-called caregivers are allowed to dispense medical pot with no medical training required at all. They apparently can even be felons. There's no definition in the amendment for that. That goes beyond, I think, happen to be 21. In addition to that, the teenager loophole. Under Amendment 2, teens will be able to legally purchase pot without their parents' consent because they will be able to get it through that caregiver who can go to the certified dispensary and pick it up. And so there are, look, I question why the proponents of medical marijuana would go through this process versus the legislative process. The Florida sheriffs, the state legislature just got behind medical marijuana for truly debilitating medical diseases when we passed Charlotte's Web, which is a extract of marijuana that has been shown to have efficacy in treatment of intractable epilepsy and some other truly debilitating medical diseases. This is not a bunch of folks who have no compassion for folks who are dealing with truly medical debilitating conditions. So let me read very quickly for you also who opposes this. This is not just the Florida Sheriff's Association. Medical marijuana is opposed by the American Medical Association, the American Psychiatric Association, the National Cancer Institute, the National Academy of Sciences, the American College of Physicians, and the American, well, I already said the American Cancer Society. So there are also tests out there that show the dangers of medical marijuana, particularly on young developing minds. And by Northwestern, and we'll talk about some of those others later, I will give you a site that you can go to this is out of the Multiple Sclerosis National Society magazine. Go to a site called procon.org, and they have a tremendous amount of information on here, in there about medical marijuana.
Okay, so now we will have opening rebuttal. Jim, you'll go first, and Sheriff, you'll go second. Let me just mention, there are slips of paper, blank slips of paper in the middle of your table. If you would like to ask a question, please write down your questions. We're not going to take any orally. And if you will then raise the piece of paper when you've got a question. Christian, would you keep an eye on it and go around and collect anybody that's got any questions and then give them to Bert Beavis. Bert, where's Bert?
Down here.
Right up here. Please give them to Bert for him to review. So 2 minutes.
Well, with only 2 minutes, let me go back to what I think the central point is. You know, for my largest client is a large group of cancer treatment doctors. We started off in Fort Myers, Florida with 3 offices. Today they're a large business in 17 states, 175 medical offices. In Florida this year, approximately 114,000 people will be diagnosed with cancer, exclusive of skin cancers. More than half of those people will get chemotherapy and radiation therapy, which tends to make them nauseous. A lot of the doctors I represent would dearly love to be able to give patients or prescribe for patients some form of cannabis, probably not to smoke, probably in some sort of edible that they could use to relieve their nausea. Dr. Michael Caton, who I work with, he gave me a list of what he thought would be the other debilitating medical conditions. I talked about spinal stenosis. He went through a couple of heart conditions. He said cardiomyopathy, where you've got damaged heart muscle and you have constant chest pain. Congestive heart failure, which gives you a suffocating syndrome. There's a firing nerve disease called RDS that gives you constant pain. He rattled off the top of his head about 10 things that he would say that were not on this list that are debilitating medical conditions. The law, okay, the amendment says you have to be examined by a doctor. That doctor is putting his medical license on the line. I have been to the Board of Medicine with doctors who are in trouble. They're very serious about this. They pull people's ticket all the time. So to think that somebody's just going to say, oh, you have a debilitating medical condition because you have a cold or you don't feel well or you just want some marijuana is just insane. It's saying that the whole Board of Medicine process doesn't work, that we have a whole bunch of dishonest doctors in Florida. That's just not true, folks. That's not the way this works. And another thing, the Florida legislature was really goaded into, I think, passing this because this amendment got on the ballot. But what they passed is so restrictive. It's only 3 diseases. And it doesn't have any loophole to say, oh, yes, doctor can make a judgment. And it's a very low THC form of cannabis, okay, which is appropriate for some things like seizures, but it's not appropriate for everything. So, again, as a student of that process, I would rely on them to make the rest of the rules.
2 minutes.
Well, I, for one, do not trust all doctors. I can tell you I put several of them in jail in Jacksonville running pill mills. So, no, I do not trust all doctors. I can tell you that. And, mentioning that their license is going to be on the line for these is interesting because, again, no one ever wants to talk about the language that's actually in the bill. They want to talk about the need, the compassion, all of that. But let's talk about the language in A1, or actually we'll talk about A2 because it deals with the physicians first. This is under public policy. A physician licensed in Florida should not be subject to criminal or civil liability or sanctions under Florida law for issuing a physician's certification to a person diagnosed with a debilitating medical condition in any manner consistent with this section. No, you're not going to be able to go after a doctor when he gives it to someone for anxiety and someone challenges that and says, well, anxiety is not debilitating. Well, who are you to make that decision? The doctor says it's debilitating. And the language is very clear. This is why the state Supreme Court let this go through. It's very clear. It means what it says. Or any other medical condition for which a physician believes medical marijuana outweighs the risk to the patient. And folks, what that means is everywhere we had a pill mill, we're going to have a pot shop. And the enforcement issues that is going to bring to law enforcement, trying to figure out who are the caregivers and who are the pushers, is going to be incredibly, incredibly difficult. A lot of people will be hurt by Amendment 2.
Okay, Peggy, this is now going to be 1 minute for both the person that answers the question and for the other speaker to be able to have their chance to answer the question. So, Jim, we'll start with you first if you'd like to stand up there. Let me ask the first question. So, in your opinion, why does Amendment 2 need to be in the Constitution specifically?
Well, I think it needs to be in the Constitution because at the federal level, Barney, this is still a Schedule I drug, okay? And until the federal laws changed, if you don't have, like the immunity that the sheriff just pointed out, and if you don't have a constitutionally protected scheme down here, I don't know of a doctor that would go out and certify that you have a debilitating medical condition. You have to give people some protection for this to work. By the way, the Congress, the U.S. House of Representatives, led by the Republicans, passed an amendment that said federal law enforcement should not use any money to enforce this law against marijuana. It hasn't been passed by the Senate, okay? But until someday, the feds back off here, medical professionals are going to have some protection, or they're not going to do this.
Sure. You have 1 minute to respond.
Listen, again, I go back to the fact that and this is one thing that upset me so much about the way that this has been placed on the ballot. It talks about debilitating medical conditions. But unless you actually go and read the amendment, nowhere in this ballot summary, are you told that it could be anxiety, that it could be, you know, headaches, it could be, not that headaches can't be debilitating, obviously they can, but any other, you know, I got a sore back, I got tennis elbow. Those are the issues that really scare, you know, us in law enforcement. And you know, this issue of immunity for the physicians, it goes beyond the physicians. It also goes to those who cultivate and produce the marijuana. And the only people that are not immune, all of you employers, are employers and parents. Thank you.
Okay, so the next question, Jim, the question will come to you. Well, I'll tell you what, we'll switch, let's switch.
Okay.
Sheriff, we'll let you go first. So the question is, in your opinion, can an employee smoke medical marijuana before they go to work? And is there any obligation by the employee to tell their employer that they're smoking medical marijuana?
You know, that's why I oppose this going into the Constitution, because issues such as that have not been vetted. We don't really know. I don't know if I'm sitting in a restaurant and someone fires up a joint beside me before their meal, are they going to be allowed to do that? Because they are simply taking their medication. None of those things have been vetted. Look, I want medical marijuana for people who have truly debilitating medical diseases. I want to relieve people's pain and suffering. My whole life has been dedicated to helping people who are suffering. And so we're dedicated to that, but this is not the way to go about it through Amendment 2, because issues such as this have not been vetted properly. The legislature is where this needs to be taken up.
Jim, your response.
Well, first of all, I point out, you know, 23 states in America have already done this. Half the population of America today can get medical marijuana legally in their states. This goes back more than a decade. Okay, there's not some parade of horribles, or otherwise we'd be hearing about them from the sheriff and others in all these other places. Large states have done this, California, New York. Small states have done this, okay? Not many states in the South, because we're fairly conservative down here. But, you know, this has happened all over the place, and this parade of horribles has not occurred. As to this go to work after you've taken your medical marijuana or firing up a joint, first of all, in states like Colorado and other places, they have laws enacted by their legislature that say you can't smoke in a public place, you can't operate a motor vehicle, you certainly can't use it in the car. All that can be covered, as the sheriff says, by the legislature. Another thing I'd point out, you know, we had 5 days of hearings at the Department of Health that really vetted a lot of these things that will all have to be addressed.
Okay. Thank you, Jim. Remember that if you have a question that you want to have asked, just raise it. Christian here will get it and give it to Bert at the front table, and Bert will have a couple of questions from the audience that we'll have at the end. Okay, Sheriff, I'm going to ask you the next question. You'll have 1 minute to answer it. Appellate courts in both New Mexico and now Michigan have ruled that workers' compensation carriers must pay for medical marijuana for their employees. Do you think that this will lead to an increase in worker compensation insurance rates?
Listen, I am not a workers' comp professional, but I can tell you this. I think it's as plain as the language in this amendment. Yes, it will go up because employers, as I mentioned earlier, now there's no immunity in here for employers, okay? There's no immunity in here for parents, but there is immunity in here for caregivers, for the distribution centers, for the growers, for the physicians, but not employers.
Jim?
You know, the best response to this, because I'll keep harping on this. By the way, I got about 50 copies up here just about the language, no propaganda that anybody would like to see it can take. Limitations, section C. 1, nothing in this section shall affect the laws. The AMA is really, I don't think, ever taken a complete position on this. They've battled it back and forth at the House of Delegates. But they sent it off to their Council on Scientific Affairs in 1999, and they approved it.
Hey, Jim, stay up for the next question. Okay, this is probably better for the sheriff, but I think you can probably
Okay.
comment on it too. With pot being legal, will the street value drop? And if so, how much? And do they take credit cards?
Those are actually all very good questions. You know, the fact of the matter is, if you're going to grow marijuana, I've actually talked to some people in Colorado. If you're going to do this and do it right, okay, you're going to grow it organically because it's going to be used as a medicine. If you try to grow it in Florida, you're going to have to use pesticides if you're outdoors. So you're going to have to go indoors, use power, not use pesticides because people are going to be ingesting this. Okay, so that means this all costs more money than the street marijuana does. So it does not drive down the price, you know. If anything, this is more expensive. It does not collapse, you know, the business completely on the outside. But it does drive people who really have a legitimate need to go there and get a licensed, you know, product. As far as the, can you use a credit card? No, you can't. As a matter of fact, as long as this is a Schedule I drug and strictly illegal from the federal level, you can't have a bank account and be in this business. There is no bank in America because there's a law that says you can't deal with drug traffickers. Different topic.
Yeah, I just added the credit card because I was interested in that. Go ahead, Sheriff.
First I would point out that when Jim was reading the Michigan law, nowhere in there did Michigan's law say, or at least he didn't read it, or any other condition for which a physician believes that the medical use of marijuana would likely outweigh the potential health risk for a patient. Now, on the issue of the cost, Colorado's a great example. Street marijuana is still doing very well for this reason. The state has taxed it so high, there's still, now what's happening is the state is in the free market against the drug dealers. That's basically what's happened. And so far, the drug dealers are, you know, affecting the prices of marijuana in the state of Colorado.
Okay, Sheriff, stay up. This is the last question. Come on, you can clap. All right, what about employers who have drug-free policy? And Jim, you'll have a chance to answer.
Yeah, listen, you know, we have a situation right now that I have to deal with. We often send officers, we used to send officers to a lot of these other states that have medical marijuana, or now they have recreational marijuana. I refuse to send officers to those states for training. It's illegal there, but it's not legal for my employees at any time to test positive for marijuana. And so those are issues that are going to have to be addressed. And that's why I believe the legislative process is the best process for something as important as medical marijuana for people with truly, truly debilitating medical diseases.
Jim.
Well, again, back to the language in the amendment, nothing in this section shall require any accommodation of any on-site medical use in any place of education, employment, or so on. So that's covered in there. You don't have to allow an employee to come to the sheriff's department or your place of business who's been consuming medical marijuana. Second point, you know, this Colorado business. Talk about the street price of Colorado. Colorado is not what we're talking about, folks. They have full recreational use of marijuana. They started with medical marijuana 12 or 14 years ago, and then they voted, the people voted, to do, you know, the further legalization of it. That's not what we're talking about. That's not what we're talking about. So, yeah, maybe they are in competition out there. This is not what we're talking about here. Well, I would also agree with the sheriff. The legislature will be a great place to further refine this. I believe in that process. I've done it for 30 years. It's a good process, and all the questions really do get vetted, and they really usually do a great job. This thing they passed late in the session this last year did not really have any hearings, and that's why it's sort of flawed. Last thing I'd like to say is, you know, I ask you to, I need to stop.
Okay, so we're gonna go to closing remarks, 2 minutes each. Jim, you'll go first, but Bert, let me just mention that if you're a club member, we have a straw ballot that asks you what your position is, for or against it. If you haven't gotten your ballot, NEBA club members only.
Pick them up at the door.
Pick them up at the door, and Bert will be watching to make sure you only vote once. Yeah, I'm sorry, we can't take any questions. It has to be in writing. I apologize. So Jim, since you went first, you're gonna go first in the closing. You have 2 minutes, and then Sheriff, you'll have 2 minutes.
Well, I would just like to close by saying I would like you to really focus on the fact that we're not talking about legalizing marijuana here. We're talking about the medical use of marijuana. And there are many, many conditions that go beyond what this Florida Legislative Act enacted, for which people could use this medication. And particularly older people, if it's not legal, okay, if you can't get it, you know, through your doctor, they're never going to use this. Okay, so it really has to do with acceptance of it in society and by the medical community, and that's the reason we need the constitutional amendment. So I'd ask you to consider that, consider all the facts. I'd also just like to close by saying I really appreciate the sheriff coming here today and the job that he does. I think anybody that's involved in public life and gets elected should have a big hand, because
Thank you. You know, I touched briefly on this issue earlier. Look, I agree with Jim. Folks that truly have debilitating medical conditions, that have end-of-life situations that they are dealing with, tremendous pain and suffering, medical marijuana may be good for some of those. We've seen that. I'm not going to argue that case. The question is the delivery. How do you get it to them? And I can tell you, under Florida's medical necessity law, as it exists today, there are people in the state of Florida who are producing, growing, cultivating marijuana for their own medical use. I have a couple in my county that I've heard of, and I know there's others around the state. So there are ways available for those that think they really need it. Again, I want to close by asking you to go to Procon. Go to procon.org, and that's the source that the Multiple Sclerosis Society, the National Multiple Sclerosis Society, is using, and really research this, and you will see. But also get a copy of Amendment 2 and read it closely. This is not about debilitating medical conditions, not at all. And so I encourage you, for the sake of our children, vote no on Proposition 2, or Amendment 2. Sorry.
Okay, so that's our debate today. Thank you.